The Law on Public Officers and Election Law by Hector S. De Leon and Hector M. De Leon Jr., 8th edition, 2014. So this is the continuation of Chapter 2. We're now on page 26. There is no authorized proceeding by which an ineligible candidate could be stopped from running for office. Good faith does not cure a candidate's ineligibility, although it might be a good defense in a criminal prosecution. Letter B. Particular qualifications and disqualifications. Qualifications usually required of public officers. The qualifications for public office are continuing requirements and must be possessed not only at the time of appointment or election or assumption of office, but during the officer's entire tenure. Once any of the required qualifications is lost, his title may be reasonably challenged. The formal qualifications usually required of public officers include those enumerated below. 1. Citizenship. Aliens enjoy many of the rights of citizens, but they also labor under certain disabilities. It is a general principle that aliens are not eligible to public office unless the privilege is extended to them by statute. A. The enforcement of the principle needs the aid of neither statutory nor constitutional enactment or restrictions. The government is instituted by the citizens for their liberty, protection, and it is to be administered, and its powers and functions exercised only by them and through their agency. A public school teacher who, by a voluntary change of citizenship or a change thereof by operation of law, ceases to be a Filipino citizen, becomes disqualified from holding any position in the teaching service. Teaching in a public school is a public function which may be performed by citizens only. B. The qualifications prescribed for elective office cannot be erased by the electorate alone. The will of the people as expressed through the ballot cannot cure the vice of ineligibility, especially if they mistakenly believe that the candidate was qualified, and this rule requires strict application when the deficiency is lack of citizenship. Letter C. An attack on a person's citizenship may only be done through a direct action for its nullity. The proper proceedings to assail the citizenship of a naturalized citizen should be in accordance with Section 18 of CA number 473. Number 2, age. Although all persons are normally considered qualified for public office, it is nevertheless true that age may present an obstacle to the holding of such an office or of particular offices. 2A. The fact that a person has reached his majority does not necessarily qualify him, so far as age is concerned, to hold every office. The age limit for certain offices may, by constitutional or statutory provisions, be placed beyond the period of majority. Letter B. 2B. The requirement that a candidate possess the age qualification is founded on public policy, and if he lacks the age on the day of the election, he can be declared ineligible. The fact that the candidate was elected will not make the age requirement directory, nor will it validate his election. The will of the people as expressed through the ballot cannot cure the vice of ineligibility. Number 3. Right of suffrage. Since the right of suffrage is generally denied to those who are not citizens, the inclusions of unnaturalized foreigners from public office is likewise accomplished by permitting none but electors or voters to be public officers. Letter A or 3A, it has been stated that where the law is silent respecting qualifications to office, it must be understood that only electors are eligible. 3B. On the other hand, the view has been expressed that all persons are equally eligible for office, eligible to office, who are not excluded by some constitutional or legal disqualification, and that, if not thus included, persons not electors may be appointed or elected to office. This is true where the age qualification is below the minimum voting age requirements. 4. Residence. There are provisions in the Constitution and statutes prescribing residence qualifications for office. A candidate for election or appointment to an office of a political subdivision or unit may be required by provision of statute to be a resident or inhabitant thereof. The term residence and domicile, as used in many statutes, are held to be synonymous. Both import not only an intention to reside in a fixed place, but also personal presence in that place, coupled with conduct indicative of such intention. Number 5, education. As a general principle, the more education an individual has, the better and more effective public officer he will be. Yet, it is quite possible for a person to become an important asset to government even with little or no formal schooling. In many cases, however, statutes prescribe educational qualifications when they reasonably relate to the specialized demands of an office, enabling the holder to properly and intelligently perform the duties of such office. Hence, there are certain offices which can be properly filled only by persons possessing professional attainments. Number 6, ability to read and write. This qualification may lawfully be made since there is no constitutional prohibition against it, especially where it has a reasonable relationship to the duties of the position in question. 7. Political affiliation. Normally, discrimination in public employment by reason of political affiliation is proscribed by the Constitution. Since running for and holding political office are forms of political expression, there must exist a compelling state interest in order to uphold the validity of restrictions on holding political office. The Constitution and existing laws sometimes require, as a condition of eligibility to certain offices, nomination by membership in a political party or group. Number 8, civil service examination. Qualifications in an appropriate examination for appointment to positions in the first and second levels in the career service is required under the civil service law to ensure that such appointment is made only according to merit and fitness, to perform the duties and assume the responsibilities of the positions. Religious qualifications prohibited. It is well settled that religious beliefs or opinions cannot be made tests of political right and privilege. 1. The United States Supreme Court has held that a state's constitutional provision which, in effect, bars every person who refuses to declare a belief in God from holding a public office in the state unconstitutionally invades the freedom of belief and religion of the appointee to the office and cannot be enforced against him. A state's constitutional provision which prohibited ministers of any religious creed or denomination from being eligible to the state legislature was declared unconstitutional since no state interest could be discerned which would justify the burden upon the free exercise of religion imposed by the restriction. Number 2, our Constitution expressly provides that no religious tests shall be required for the exercise of civil or political rights. 2A. A religious test is one demanding the avowal of refutation of certain religious beliefs before the performance of any act. Thus, under this injunction, laws prescribing the qualification of public officials or employees, whether appointive or elective, or a voter, may not contain requirements of religious beliefs. 2B. It has been held, however, that Section 2175 of the Revised Administrative Code 1917, which provides that in no cases shall there be elected or appointed to a municipal office ecclesiastics, was not repealed by the 1935 and 1973 Constitution's provision that no religious tests shall be required for the exercise of civil or political right. In Pamil versus Teleron, the Supreme Court ruled that a priest cannot be elected as municipal mayor. The prohibition in the Revised Administrative Code of 1917 is not provided in the Administrative Code of 1987. Power of Congress to impose property qualifications. 1. View that law constitutional. The fundamental law of some states in the United States prohibits the imposing of a property qualification as a condition of eligibility to public office. A prohibition of this character has been construed as applying only to offices provided for in the Constitution as distinguished from offices created by the legislature. Holders of public office or of particular public offices have, in some jurisdictions, been required to be freeholders. The view has been taken that unless inhibited by the Constitution, a legislature has the power to impose property qualifications upon office holders, a requirement that certain public officers be resident property owners does not transgress the constitutional guarantees of due process and equal protection. Number 2, view that law unconstitutional. On the other hand, it has been decided that the ownership of land as a prerequisite to holding elective office constitutes an invidious discrimination against non-landowners, a sort of economic gerrymandering, which runs afoul of the equal protection and due process guarantees. There is no rational connection between qualifications for administering public affairs and ownership of real property. In a case our Supreme Court declared as unconstitutional a law requiring all candidates for public offices to post a surety bond equivalent to the 1-year salary of emoluments of the position for which they are candidates, which shall be forfeited if the candidates, except when declared winner, fail to obtain at least 10% of the votes cast for the office to which they have filed their certificates of candidacy. This law, according to the Supreme Court, has the effect of imposing property qualifications. The Supreme Court stated that property qualifications are inconsistent with the essence and nature of the republican system ordained in our constitutional and the principles of social justice underlying the same. Said political system is based from the tenet that sovereignty resides in the people and all government authority emanates from them. This, in turn, implies necessarily that the right to vote and to be voted for shall not be dependent upon the wealth of the individual concerned. Social justice presupposes equal opportunity for all, rich and poor alike. Accordingly, no person shall, by reason of poverty, be denied a chance to be elected to public office. Qualifications prescribed by the Constitution for certain officers. As provided in the Constitution, they are as follows. Number 1. President and Vice President. No person may be elected President unless he is a natural-born citizen of the Philippines, a registered voter, able to read and write, at least 40 years of age on the day of the election, and a resident of the Philippines for at least 10 years immediately preceding such election. There shall be a vice president who shall have the same qualifications and term of office and be elected with and in the same manner as the president. He may be removed from office in the same manner as the president. 2. Senators. No person shall be a senator unless he is a natural-born citizen of the Philippines and on the day of the election is at least 35 years of age, able to read and write, a registered voter, and resident of the Philippines for not less than 2 years, immediately preceding the day of the election. Number 3. Members of the House of Representatives. No person shall be a member of the House of the Representatives unless he is a natural-born citizen of the Philippines and on the day of the election is at least 25 years of age, able to read and write, and except the party list representatives, a registered voter in the district in which he shall be elected and a resident thereof for a period of not less than 1 year, immediately preceding the day of the election. Number 4. Members of the Supreme Court and lower collegiate court. No person shall be appointed member of the Supreme Court or any lower collegiate court unless he is a natural-born citizen of the Philippines. A member of the Supreme Court must be at least 40 years of age and must have been for 15 years or more a judge of a lower court or engaged in the practice of law in the Philippines. A member of the judiciary must be a person of proven competence, integrity, probity, and independence. Number 5. Chairman and commissioners of the civil service. The civil service shall be administered by the Civil Service Commission, composed of a chairman and 2 commissioners who shall be natural-born citizens of the Philippines and, at the time of their appointment, at least 35 years of age with proven capacity for public administration and must not have been candidates for any elective position in the elections immediately preceding their appointment. Number 6. Chairman and commissioners of the Commission on Elections. There shall be a commission of elections composed of a chairman and 6 commissioners who shall be a natural-born citizens of the Philippines and, at the time of their appointment, at least 35 years of age, holders of a college degree, and must not have been candidates for any elective position in the immediately preceding elections. However, a majority thereof, including the chairman, shall be members of the Philippine Bar who have been engaged in the practice of law for at least 10 years. 7. Chairman and commissioners of the Commission on Audit. There shall be a commission on audit composed of a chairman and 2 commissioners who shall be natural-born citizens of the Philippines and, at the time of their appointment, at least 35 years of age, certified public accountants with not less than 10 years of auditing experience, or members of the Philippine Bar who have been engaged in the practice of law for at least 10 years and must not have been candidates for any elective positions in the elections immediately preceding their appointment. At no time shall all members of the commission belong to the same profession. Number 8. Chairman and members of the Commission on Human Rights. The commission shall be composed of a chairman and 4 members who must be natural-born citizens of the Philippines, and a majority of whom shall be members of the bar. The term of office and other qualifications and disabilities of the members of the commission shall be provided by law. 9. Ombudsman and his deputies. The ombudsman and his deputies shall be natural-born citizens of the Philippines and, at the time of their appointment, at least 40 years old, of recognized probity and independence, and members of the Philippine Bar, and must not have been candidates for any elective office in the immediate preceding elections. The ombudsman must have, for 10 years and more, been a judge or engaged in the practice of law in the Philippines. Qualifications prescribed by law for certain officers. 1. Secretaries of departments. The secretaries shall be citizens of the Philippines and not less than 25 years of age. Number 2. Presiding Justice and Associate Justices of the Court of Appeals. The presiding justice and associate justices shall have the same qualifications as those provided in the Constitution for justices of the Supreme Court. Number 3, judges of regional trial courts. No person shall be appointed regional trial court judge unless he is a natural-born citizen of the Philippines, at least 35 years of age, and for at least 10 years has been engaged in the practice of law in the Philippines, requiring admission to the practice of law as an indispensable requisite. Number 4, judges of the metropolitan trial courts, municipal trial courts, and municipal circuit trial courts. No person shall be appointed judge of a metropolitan trial court, municipal trial court, or municipal circuit trial court unless he is a natural born citizen of the Philippines, at least 30 years of age, and for at least 5 years has been engaged in the practice of law in the Philippines, or has held a public office in the Philippines requiring admission to the practice of law as an indispensable requisite. Number 5, elective local officials. They are as follows. An elective local official must be a citizen of the Philippines, a registered voter in the barangay, municipality, city, or province, or in the case of a member of the Sangguniang Panlalawigan, Sangguniang Panlunsod, or Sangguniang Bayan, the district where he intends to be elected, a resident therein for at least 1 year immediately preceding the day of the election, and able to read and write Filipino or any other local language or dialect. Letter B, candidates for the position of governor, vice governor, or member of the Sangguniang Panlalawigan, or mayor, vice mayor, or member of the Sangguniang Panlunsod of highly urbanized cities must be at least 23 years of age on election day. Letter C, candidates for the position of mayor or vice mayor of independent component cities or municipalities must be at least 21 years of age on election day. Letter D, candidates for the position of member of the Sangguniang Panlunsod or Sangguniang Bayan must be at least 18 years of age on election day. Letter E, candidates for the position of punong barangay or member of the Sangguniang Barangay must be at least 18 years of age on election day. Letter F, candidates for the Sangguniang Kabataan must be at least 15 years of age, but not more than 21 years of age on election day. Number 6, members of the Board of Election Inspectors. No person shall be appointed chairman, member, or substitute member of the Board of Election Inspectors unless he is of good moral character and irreproachable reputation. A registered voter of the city or municipality has never been convicted of any election offense or of any other crime punishable by more than 6 months of imprisonment. Or if there is a pending information against him for any election offense, he must be able to speak and write English or the local dialect. Disqualifications to hold public office. In general, individuals who lack any of the qualifications prescribed by the Constitution or by law for a public office are ineligible or disqualified from holding such office. An appointment of an ineligible or unqualified person is a nullity. The disqualification to hold a public office may arise from a variety of causes. Among them are mentioned below. Number 1, mental or physical incapacity. From the very nature of the case, an idiot or other person non compos mentis is incapable of accepting or holding public office. The law may expressly require that a public officer be in possession of his mental faculties, while a blind person may labor at a disadvantage in certain public offices. His affliction does not necessarily disqualify him. If he possesses the other qualifications imposed by law and there is no provision of the law excluding him from the office. Because of his blindness, he may be eligible to the office. Number 2, misconduct or crime. To assure public confidence in the essential integrity of the government, persons convicted of crimes involving moral turpitude are usually disqualified from holding public office. The provisions of a statute prohibiting convicted persons from qualifying for office promote honesty and integrity in candidates for and holders of public office. Letter A. Whether the ineligibility to hold office because of crime results from the mere commission or arises only after prosecution and conviction depends to some extent upon the wording of the applicable constitutional or statutory provisions. Letter B. It has been held that the legislative requirement that a person must have no criminal record in order that he may qualify for appointment was not intended to automatically cover every violation of a municipal or city ordinance carrying a sanction of a minimal fee to enforce it. A violation of a municipal ordinance to qualify as a crime must involve at least a certain degree of evil doing, immoral conduct, corruption, malice, or want of principles reasonably related to the requirements of the public office. The Supreme Court, however, did not go so far as to sustain the arguments that only violations of statutes enacted by the national legislature can give rise to crimes or a criminal record. As these terms are used in our law on local government or the law of public officers, it took cognizance of the distinction in the law of municipal corporations, which distinguishes between acts not essentially criminal relating to municipal regulations for the promotion of peace, good order, health, safety, and comfort of residents. For example, jaywalking, traffic violation, etc. And acts intrinsically punishable as a public offense. A penalty imposed for the breach of a municipal regulation is not necessarily an exercise of the sovereign authority to define crimes and provide for their punishment, delegated to a local government. In many cases, the penalty is merely intended not to render the ordinance inoperative or useless. Number 3, impeachment. Under the Constitution, the President, the Vice President, the members of the Supreme Court, the members of the Constitutional Commissions, and the Ombudsman may be removed from office on impeachment for and conviction of culpable violation of the Constitution. Treason, bribery, graft, and corruption, other high crimes or betrayal of public trust. Letter A. Judgment in cases of impeachment is limited to removal from office and disqualification to hold any office under the Republic of the Philippines, but the party convicted shall nevertheless be liable and subject to prosecution, trial, and punishment according to law. Letter B. The penalties attached to impeachment are merely incidental to the primary intention of protecting the people as a body politic. Number 4. Removal or suspension from office. The grounds for removal or suspension from office include acts which would disqualify one from holding office. The qualification here is whether the suspension or removal itself operates to disqualify one from holding the same or another office. Letter A. Undoubtedly, the law can attach ineligibility to suspension or removal from office. Removal from office. But where there is no constitutional or statutory declaration of ineligibility for such cause, the courts may not impose the disability. The cases have generally held that a removal from office bars the removed officer from an election or appointment to fill the vacancy for the unexpired term, but that it does not disqualify him to take some other office or to be elected or appointed to a new term of the same office. Hence, a judgment of ouster may not preclude the offender from entering in a succeeding term to which he has been elected before the judgment was entered. Letter B. The above principles apply likewise in cases in which a public officer anticipates his removal for crime or misconduct in office by first tendering his resignation. Even if it is accepted, he is not thereby rendered eligible for election to the vacancy for the balance of the term caused by his resignation to escape expulsion. Number 5. Previous tenure of office. Under the Constitution, a disability to succeed to office is imposed upon certain officers. Letter A. The President is not eligible for any re-election. In other words, a person who has been elected to and has held the office of President is absolutely disqualified for any re-election regardless of the length of time he has served as such. A person who has succeeded as President is disqualified only if he has served as such for more than 4 years. Letter B. The chairman and the commissioners of the Civil Service Commission on Elections and Commission on Audit and the Ombudsman and his deputies are appointed by the President without pre-appointment. Furthermore, the Ombudsman and his deputies shall not be qualified to run for any office in the election immediately succeeding their cessation from office. Number 6. Consecutive terms. The Constitution likewise prohibits the holding of certain elective offices by the same persons for more than a stated number of consecutive terms. Letter A. The Vice President shall not serve for more than 2 successive terms. Voluntary renunciation of the office for any length of time shall not be considered as an interruption in the continuity of the service for the full term for which he was elected. Letter B. A senator shall not serve for more than 2 consecutive terms. Voluntary renunciation of the office for any length of time shall not be considered as an interruption in the continuity of his service for the full term for which he was elected. Letter C. A member of the House of Representatives shall not serve for more than 3 consecutive terms. Voluntary renunciation of the office for any length of time shall not be considered as an interruption in the continuity of his service for the full term for which he was elected. The term of office of elective local officials, except barangay officials, which shall be determined by law, shall be 3 years, and no such official shall serve for more than 3 consecutive terms. Voluntary renunciation of the office for any length of time shall not be considered as an interruption in the continuity of his service for the full term for which he was elected. Number 7, holding more than one office. There is no constitutionally protected right to hold incompatible offices. The letter A, the rule against holding incompatible offices does not result in an unconstitutional infringement of personal and political rights. In fact, it is said that a state has a legitimate interest in preventing one person from holding multiple public offices. The manifest purposes of a restriction on multiple holdings are to prevent offices of public trust from accumulating in a single person, and to prevent individuals from deriving, directly or indirectly, any pecuniary benefit by virtue of their dual position holding. Letter B, even if the duties do not conflict, the consolidation of government functions in a single person could adversely affect the freedom of expression by others, where a person is prohibited from holding two offices at the same time. His appointment or election to a second office may operate to vacate the first, or he may be ineligible for the second. Letter C. In other words, a person who accepts and qualifies for a second and incompatible office is deemed to vacate, or, by implication, to resign from the first office. The same rule obtains where the holding of more than one position is prohibited by constitutional or statutory provision, although the second position is not incompatible with the first. The Constitution imposes limitations on the right of certain officials to hold more than one office at the same time. Letter A, the President, the Vice President, the members of the Cabinet, their deputies or assistants shall not, unless otherwise provided in this Constitution, hold any other office or employment during their tenure. Letter B. A senator or member of the House of Representatives may not hold any office or employment in the government or any subdivision, agency, or instrumentality thereof, including government-owned or controlled corporation or their subsidiaries, during his term without forfeiting his seat. If he accepts any other office or employment during his term, not tenure, he forfeits his seat. Letter C. The members of the Supreme Court and of other courts established by law shall not be designated to any agency performing quasi-judicial or administrative functions. Letter D. A member of the Constitutional Commission shall not, during his tenure, hold any other office or employment. Letter E. During their tenure, the Ombudsman and his deputies are subject to the same disqualifications and provisions as provided for members of the constitutional commissions. Letter F. Unless otherwise allowed by law or by the primary functions of his position, no appointive official shall hold any other office or employment in the government or any subdivision, agency, or instrumentality thereof, including government-owned or controlled corporations of their subsidiaries. Letter G. No member of the armed forces in the active service shall at any time be appointed or designated in any capacity to a civilian position in the government, including government-owned or controlled corporations or any of their subsidiaries. Number 8. Relationship with the appointing power. Since a public office is a public trust, created for the benefit and in the interests of the people, appointments there too should be based solely on merit and fitness, uninfluenced by any personal or filial consideration. Letter A. The Constitution prohibits the President from appointing his close relatives to high positions in the government. Thus, the spouse and relatives by consanguinity or affinity within the fourth civil degree of the President shall not, during his tenure, be appointed as members of the constitutional commissions, or the office of the ombudsman, or as secretaries, undersecretaries, chairman, or heads of bureaus of offices, including government-owned or controlled corporations and their subsidiaries. Letter B. Under the Civil Service Decree, all appointments in the national, provincial, city, and municipal governments or in any branch or instrumentality thereof, including government-owned or controlled corporations, made in a favor or a relative of the appointing or recommending authority or of the chief of the bureau or office or of persons exercising immediate supervision over him are prohibited. As used in the law, the word relative and members of the family referred to are those related within the third degree, either of consanguinity or of affinity. The restriction shall not be applicable to the case of a member of any family who, after his or her appointment to any position in an office or bureau, contracts marriage with someone in the same office or bureau, in which event the employment or retention therein of both husband and wife may be allowed. Letter C. In each particular instance, full report of such appointments shall be made to the Commission in order to guarantee that the law is duly observed. It is required, among others, that the appointment paper should be accompanied by a certification of the appointing or recommending authority stating therein that he is not related to the appointee within the third degree of consanguinity or affinity. Letter D, the following are exempted from the operation of the rules on nepotism. Number 1, persons employed in a confidential capacity. Number 2, teachers. 3, physicians. 4, members of the Armed Forces of the Philippines. Number 9, office newly created or the emoluments of which have been increased. The Constitution prohibits the appointment of a senator or a member of the House of Representatives to any office which may have been created or the emoluments thereof increased during the term for which he was elected. Letter A. To create a new office within the meaning of such provision, Congress must itself cause it to exist or bring into existence. And it does not do so where it leaves the creation of the office to the people or merely provides a new method of filling an office or simply adds new or additional duties to an office. Letter B. If the increase in the emoluments is not affected by a provision enacted by Congress, but by the act of some other body or officer, the prohibition does not apply. The purpose sought to be accomplished by such provision is not merely to prevent an individual legislator from profiting by an action taken by him with bad motives, but to prevent all legislators from being influenced by either conscious or unconscious selfish motive. The term emolument does not refer to the fixed salary alone that is attached to the office, but includes such fees and compensation as the incumbent of the office is by law entitled to receive. Number 10. Being an elective official under the Constitution, no elective official shall be eligible for appointment or designation in any capacity to any public office or position during his tenure. The Constitution seeks to minimize the so-called spoil system. The disqualification subsists only during the tenure in office, not term of office, of the elective official. He may be appointed provided he forfeits his seat. 11. Having been a candidate for any elective position. Under the Constitution, no candidate who has lost in any election shall within 1 year after such election be appointed to any office in the government or any government-owned or controlled corporations or in any of their subsidiaries. The provision is directed against the so-called political lame ducks. Members of the Constitutional Commission must not have been candidates for any elective position in the elections immediately preceding their appointment. Number 12. Under the Local Government Code, the following persons are disqualified from running for any elective local position. A. Those sentenced by final judgment for an offense involving moral turpitude or for an office punishable by 1 year or more of imprisonment within 2 years after serving sentence. B. Those removed from office as a result of an administrative case. C. Those convicted by final judgment for violating the oath of allegiance to the Republic. Letter D. Those with dual citizenship. Letter E. Fugitive from justice in criminal or non-political cases here or abroad. Letter F. Permanent residents in a foreign country or those who have acquired the right to reside abroad and continue to avail of the same right after the effectivity of this code. And letter G. The insane or feeble-minded. With respect to the appointment of elective and appointive local officials and candidates who lost in an election, the code provides: A. No elective or appointive local official shall be eligible for appointment or designation in any capacity to any public office or position during his tenure, unless otherwise allowed by law or by the primary functions of his position. No elective or appointive local official shall hold any other office or employment in the government or any subdivision, agency, or instrumentality thereof, including government-owned or controlled corporations or their subsidiaries. Letter B. Except for losing candidates in barangay elections, no candidate who lost in any election shall, within 1 year after such election, be appointed to any office in the government or any government-owned or controlled corporations or in any of their subsidiaries.